Even the most amicable divorce or separation is likely to be difficult and stressful at times. If you're already feeling upset and angry, then worrying about legal proceedings, your financial arrangements, and what happens to you and your children can be an additional concern. If you have not consulted a solicitor before, you may also feel anxious about seeking legal advice. In fact, this is one of the wisest moves you can make. Divorce law has been designed to be flexible enough to meet the different needs of every couple affected. Around 150,000 marriages end in divorce each year in England and Wales alone. So at times it can seem complex and confusing. I will now cover some of the key points relating to separation and divorce. For simplicity, I will use the term partner to mean a husband or wife. Or simply put, anyone who has been married for over a year. It does not matter where you were married, provided at least one partner is either domiciled or resident in England or Wales. The only ground for divorce is that the marriage has irretrievably broken down. This must be established by one of the following 5 facts. Your partner has committed adultery and you find it intolerable to continue living together. The adultery can occur after you've already separated. Your partner has behaved in such a way that you cannot reasonably be expected to live with them. Your partner has deserted you for a continuous period of 2 years or more. You and your partner have been living separately for 2 years or more, and your partner agrees to the divorce. You and your partner have been living separately for 5 years or more, whether or not your partner consents to the divorce. If you are filing for divorce, you set out your evidence in a document called a petition. If you file, you are the petitioner, and your partner is the respondent. Once you file your petition with the appropriate court, you have started the divorce process. What happens next depends on whether or not your partner contests or agrees to the divorce. It is sensible to seek your partner's agreement to a divorce and to try to reach agreement over the contents of the divorce petition before proceedings are started, especially in cases of adultery or unreasonable behaviour. Your partner will receive a copy of the petition and must acknowledge receipt of it, indicating whether they agree to a divorce. If they do, the procedure is relatively straightforward. If a judge is satisfied that there are grounds for divorce and that your partner does not wish to contest it, he will pronounce a decree nisi. This is the first stage of the divorce. 6 weeks thereafter, you can apply for the final divorce decree, known as the decree absolute. The decree absolute brings the marriage to an end. It is not necessary for a financial settlement to be completed by the time the divorce is made final. Quite often, financial negotiations will still be in the early stages, particularly if finances are complicated. In many cases, however, it may actually be advantageous to delay the final divorce decree until financial matters are resolved. Any financial order will only come into force after the decree has been made absolute. It is important to keep the decree absolute safe, as you will not be able to remarry without it. Either party, regardless who started divorce proceedings, can claim financial remedies. These remedies may include a sale or transfer of property, maintenance payments, a lump sum of money, and a pension sharing or attachment order. Such a claim can be made at any time, sometimes many years after the divorce, but a respondent who remarries after the divorce loses the right to make such claims. There are various ways in which you might obtain a financial settlement following the breakdown of the marriage. You and your partner might be able to agree everything between yourselves, with no need for legal advice. You might, however, wish to seek legal help to record any such agreement so that the agreement is certain and binding upon you both. You might wish to consider mediation, a process which enables you and your partner to discuss a settlement with an independent third party who will help you try to reach an agreement. You may still need legal advice upon any proposals made in the mediation process. you might each want legal advice from your solicitors. Traditionally, each of you would have your own solicitor negotiate on your behalf and to look after your respective interests. If you are both keen to avoid hostility and are looking for a solution which is beneficial to both of you and to your family, then collaborative law may suit you best. In the collaborative process, you and your partner meet together with your solicitors to discuss the financial consequences of your separation and to consider the possible solutions. This usually involves at least 2 or 3 meetings together as a group. Each of you can still have legal advice from your solicitor, but the solicitors will work together to help you reach an agreement. If you cannot resolve an issue in one of these ways, then you can still apply to the court for a financial order. However, before doing so, the court will expect you to have at least considered mediation as an alternative. Each party will be expected to attend a Mediation Information and Assessment Meeting, a MIAM, either together or separately. The purpose of such a meeting is to explain the process of mediation and to help you decide whether this might be suitable in your case. If a court application does prove necessary, one party will issue proceedings for financial remedy, which are separate from the divorce itself. The court will give directions as to how the case should proceed. These directions will include a requirement that both parties disclose their financial circumstances to the other by completing a financial statement, a document known as Form E. This is a detailed statement of your current financial position and includes any other information which you may feel the court should take into account when dividing your money and property. You must attach your Form E to various documents to prove your financial position, such as bank statements and pension valuations. These financial statements and accompanying documents must be filed with the court and a copy provided to your partner or their solicitor. A judge will consider both parties' financial statements at an initial court hearing, known as a first directions appointment. At this hearing, the judge will ensure that the parties have each made a full disclosure of their financial positions, supported by the relevant documentation. The judge will decide what other documents may need to be obtained or disclosed for the case to be progressed. Perhaps, for example, a valuation of property. If each party has already made a full disclosure of their financial position and nothing further is required, then this hearing may become a financial dispute resolution hearing, when the judge will hear a summary of each party's case, what they are hoping for, and why they think their proposals would represent a reasonable settlement. The judge may comment on each party's position and will encourage them to negotiate. If the parties reach an agreement at this hearing, the judge will record the agreement in a court order, which is called a consent order, bringing the case to an end. If, despite some negotiation and the judge's comments, the parties cannot reach agreement, then a further final hearing will be fixed when the court will decide the matter. The court will make an order, which will be final and binding upon both parties. If you need help deciding whether to apply for an order or what the outcome might be, it would be wise to seek legal advice. Even if you think you can reach an agreement with your partner, talking to a solicitor will make sure your interests are protected. The specialist family team at our firm can assist you with all family-related issues, including those relating to divorce and separation. To find out more about how we can help you, please contact our family law specialists using the contact details shown on this screen